turn up to
You ready?
Yeah.
Y'all ready?
Yes, sir.
Robert, you ready?
Yes, sir.
Welcome, everyone, to the Southern Shores Special Planning Board meeting today, October 5th, 2022. If you will please stand and join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay. Could I get everybody have a chance to look at the agenda? It's pretty straightforward. I would entertain a motion to approve the agenda.
I'll make a motion to approve the agenda for
Thank
the
you, Tony.
special meeting, October 5th, 2022.
Second.
Ed, thank you. Second. All in favor? Opposed, none seen. Okay. We have on the agenda public comment. No one has signed up, but if anyone wishes to speak prior to the hearing, they may come forward and address us at the lectern. Anybody? Okay. All right. Well,
It's okay.
moving on to new business. This is where we will be. We are the planning board sitting up here, but this is where we will be performing the duties of the Southern Shores Board of Adjustment with a public hearing to consider APA-22-01, an appeal application submitted by Adam Ward to appeal the zoning administrator's decision to deny approval of a recombination plat for the property located at 55 Skyline Road. At this point, I am going to turn things over to our board's attorney, Mr. Jay Wheelis.
Thank you, Mr. Chairman. Good afternoon, everyone. Please bear with me. I've got some things to read, some comments, some remarks, some procedural items. The planning board is now acting as the Town of Southern Shores Board of Adjustments and is scheduled to hold a quasi-judicial hearing at this time. Momentarily, we will open the evidentiary hearing for this matter known as APA 22-01, the appeal of Skyline Oaks Properties, LLC. Distilled down, the appellant believes the zoning administrator incorrectly denied its proposed recombination plat for property at 55 Skyline Road. Prior to the receipt of any evidence, I present the following preliminary remarks and questions to the parties, the board members, and to the alternate members. The board's decision will be made by a simple majority vote on all issues and the ultimate issue before it today. This hearing is a quasi-judicial evidentiary hearing. State law sets specific procedures and rules concerning how this board must make its decision. These rules are different from other types of land use decisions, like rezoning cases. This board is not comprised of attorneys or land use experts. Some issues could arise during the hearing that may be quite complicated, and this board will do its level best to decide all matters fairly and properly. The board's discretion is limited, though. The board must base its decision upon competent, relevant, and substantial evidence in the record. A quasi-judicial decision is not a popularity contest. It is a decision constrained by the standards in the ordinance and based on the facts presented during the hearing. If you are to be a sworn witness, please focus on the facts and the standards, not personal preference, opinion, or hearsay. Participation in this hearing is also limited. The meeting is open to the public and everyone is welcome to watch, but only parties with legal standing have a right to participate fully. Parties may present evidence, call witnesses, and make legal arguments. Parties are limited to the applicant, the town, and individuals who show they are aggrieved by special damages not suffered by the ordinary public. Other individuals may serve as witnesses when called by either of the parties or the board. General witness testimony is limited to facts, not opinions. For certain topics, the board needs to hear opinion testimony from expert witnesses. These topics include projections about the impacts on property value and projections about traffic flow, congestion, and so forth. If the need for such testimony arises, individuals providing expert opinions must be qualified as experts before this body and provide the factual evidence upon which their expert opinions are gathered and testified to. As mentioned, most decisions will be made by the board by a simple majority. From time to time, however, we might expect the attorneys to make evidentiary objections. As a board, I would like for you to authorize the chair to rule on such objections without entering into a full-blown discussion with the board. I will help the chair as best I am able to make decisions on any objection or matter of evidentiary procedure. Do any of you object to this? Now, let us open the appeal for hearing. First, we will determine whether there are any conflicts for board members or challenges for cause from the parties. Board of Adjustments members shall not participate in or vote on any quasi-judicial matter in any matter that would violate the affected person's constitutional rights to an impartial decision. We have one member, Mr. McClendon, who has an outright conflict in that he is an owner member of the applicant LLC, and I understand that he recuses himself. Is that right, Mr. McClendon?
That's correct.
Thank you very much. Mr. McClendon is excused, and one of the two alternates needs to be seated. I believe that to be Mr. Fink. Is that right? Because he did not participate in the last one, but Ms. Collins did. Thank you. Mr. Fink, do you have any objection to the chair making all evidentiary and, all hearsay and so forth, ruling on those without full board participation?
No.
Thank you. Turning my attention to the balance of the board, I ask these 4 questions of any of you. Has any member communicated with other board members, parties, or their attorneys or town staff about this matter? Does any board member have a fixed opinion that is not susceptible to change? Does any board member have a close familial, business, or associational relationship with any party? Does any board member have a financial interest in the outcome of this matter? Ms. Burrick, do you answer affirmative to any of those questions? Mr. DiBernardo?
No.
Mr. Lawler?
No.
And Mr. Fink?
No.
Coming back to the chair, Mr. Ward,
Yes, I do.
can you describe to us what that is, please?
Yes. I had an inadvertent conversation with one of the owners of 55 Skyline Road prior to the filing of their appeal. Therefore, I will ask to recuse myself and will leave the hearing at this time.
Hearing no objection from the rest of the board, it is appropriate that he recuse himself. Thank you, Mr. Ward. Ms. Collins, congratulations. And Mr. DiBernardo will rise to the level of chair, please. Ms. Collins, do you have any objection to the chair ruling on objections entered by either party on evidentiary matters?
No, sir.
Thank you. Do you answer affirmative to any of those 4 questions that I asked about conflicts of interest or bias?
No, sir.
Thank you. Were you able to hear her answers, Madam Clerk? Thank you. I promise we are almost there. These remarks are addressed to the board. An appeal from a decision of the zoning administrator is similar to, but certainly not the same as, a variance hearing. Like in a variance hearing, you are the finders of fact. Your duty is to review the record, hear testimony, consider documents, and in the end, hear arguments from the parties and/or their attorneys. You are to make one of the following decisions: affirm in whole or part the denial of the recombination plat. Reverse in whole or part the denial of the recombination plat. Or modify the denial of the recombination plat. You have all the powers of the zoning official who made the decision to disapprove this particular recombination plat. Each decision requires a 3/5 vote, not a 4/5, like in a variance, so a simple majority carries the day. As in a variance, it is very important that your decision be complete with a full account of the reasons, the facts upon which you base your decision. Your consideration of the appeal might necessarily mean that you need to interpret what certain language in the ordinance means. Accordingly, I give you this guidance. Your primary objective is to determine the intent of the town council in adopting the language in question. You should do the following things. Number one, listen carefully to the arguments of the town and the appellant. Number two, determine and give effect to the intent of the Board of Commissioners. Number three, examine the ordinance text itself. If it is clear and unambiguous, apply the text as written. If the ordinance provides definitions, consider those definitions thoroughly. Number five, if the ordinance provides an interpretive guidance, use it. Number six, contrast other provisions in the ordinance to provide meaning to the terms or the sections in issue. Number seven, apply a logical meaning to words. Number eight, use the dictionary if necessary. Number nine, avoid absurdity. Number 10, if ambiguity exists, resolve it in favor of the property owner and the free use of land. Witnesses in this hearing must be sworn prior to their testimony. If you are to be a witness, please stand, raise your right hand, and you will be affirmed. Are you doing it?
I am.
Go ahead.
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Excellent, thank you. Mr. Chairman, I turn this evidentiary hearing over to you.
Good afternoon. Just one housekeeping, if everybody could turn their phones off or put them on silent, it would be appreciated during this hearing. The appellant will present the evidence first. Mr. Varnell,
Thank you,
you're up.
Mr. Chairman. I'll call my first witness.
Please.
I'll call Mr. Robert McClendon. Can you stand? Or podium. Forgive me if I get into the courtroom dialogue like that, I'm sorry. All right. Would you please state your name?
Robert McClendon,
And Mr. McClendon, where do you reside?
146 High Dune Loop in Southern Shores,
How long have you been a Southern Shores resident?
10 years.
This is somewhat duplicative, as the subdivision plat was attached, of course, to the application, but I'll hand that up just so we can get some clarity on that. The parcels of land shown on that plat, are you the owner or an owner of those parcels?
Yes, I'm an owner.
And when you say an owner, what does that mean?
The property is owned by an LLC, of which I am a member.
How many other members?
There are a total of 4 members in the LLC.
And the land, again, is titled in the name of that LLC?
That's correct.
And what's the LLC's name?
Skyline Oaks Properties LLC.
When did you and your partners in the LLC purchase this particular, or these particular parcels?
In June of 2021, July, maybe August. I'm not sure exactly when the closing date was.
Okay. Have you commenced any construction or anything on these
No.
parcels?
No.
They exist as vacant parcels today?
That's correct.
In terms of the purchase itself, did you acquire, or did the LLC require all of the parcels at one time, or did you?
No, they were,
over time?
no, they were purchased all with a single sale.
So just for the board, it kind of explained the makeup of the parcels as they currently exist without any form of recombination or subdivision. How many parcels of land are we really dealing with here?
There are 4 platted lots that were platted in 1949, I think. They've been held in the same ownership since 1952 until we purchased it in 2021. There are 4 platted parcels, and then there is an adjacent parcel of land as well.
So, so then your testimony is that what we're dealing with here, as far as when you say 4 lots, these were lots shown on the original subdivision plat or a recorded subdivision.
That's
plat
correct.
of that section of Southern Shores.
Yes, they were recorded there, yes.
And describe the excess land. I'm calling it excess, but you refer to it as an adjacent parcel.
Right. It's about 100 feet behind each parcel and the same behind every one of those parcels. The 4 platted lots, there's an additional 100 feet on each edge, outside edge, so it's a little more than 100 feet in the center, I think. I'm not sure.
May I approach the witness?
Yes.
When I hand you this document, I would just, for judicial notice, this is an unmodified version of the recorded subdivision plat, recorded with the Dare County Public Registry.
Which subdivision?
Southern Shores, amended section 1, amended portion, the plat's title is amended portion, section 1, Southern Shores.
Book and page?
I think Matt looked through page 91.
Thank you.
In looking at this particular plat, Mr. McClendon, do the parcels of land that you just testified to is on, do they exist on this on this plat?
Yes, they do.
And I noticed that there's a drawn in, and again, for the judicial notice, this is unmodified. This is how the document is recorded with the Register of Deeds. But there's a drawn in portion of land existing behind the 4 lots that you own. Is that adjacent parcel you were referring to?
That's correct, yes.
Excuse me, Mr. Vernell, do you have a
I
copy?
was about to move to introduce it into evidence and then hand you guys copies.
Yeah.
Having said that, and again, with this being a recorded document, Chairman, I'd ask to introduce this amended portion, section 1, Southern Shores subdivision plat. As plaintiff's exhibit 1 or petitioner's exhibit 1.
Mr. Haas, is there any objection?
No objection. May I approach?
Yeah.
Who do you
We
want me to hand it
receive.
to? Jay, do you want me to hand it to you or how do you want me to?
That'd be fine, and I'll help hand them out. And if we want to put it on the overhead, we'll ask if that be done, if it's possible. Thank you.
I'm going to pause while you guys review.
Mr. Parnell, we're going to call this plaintiff's exhibit number 2. Number 1 will be your board, your packet of
Understood.
appeal
Understood.
application.
Mr. McClendon, I'll ask the board first, have you guys reviewed the plat, just to look at the parcels and at least the testimony that was just provided? Okay. What again, I'm calling this excess parcel, which was actually drawn in by, we assume, the developer when it got recorded. Do you believe that it makes your land or the parcels that you own unusual to adjacent properties or nearby properties
Yes, I do. Yes, certainly.
How so?
The other parcels that were platted in 1949 are fixed in size, and we have 4 parcels that could be re-subdivided or recombined or something like that. It's not very often that people have the opportunity to acquire an undeveloped piece of property that's adjacent.
And does this undeveloped piece of property, do you believe, I'll call it a larger area, of course, that is creating, is that why you were able to design the subdivision that you proposed and was denied? Is that the reason you were able to design it in the manner you did?
Yes, certainly. Yes.
And without having this excess land or adjacent parcel, would you even be here today attempting the subdivision of this nature?
No, certainly not.
Mr. McClendon, I had you up there. I wanted really for you just to establish your ownership of the property, given you are the underlying landowner. Is there anything else that you'd like to add before I turn you over to opposing counsel?
I will just say this, that I have a master's degree in landscape architecture from NC State. I've studied sustainable design, low impact development. That's what I did primarily in my professional career. And the question's always asked why more people don't try to save trees and why they don't try to develop in a more sustainable manner. And the answer is time and money. And we have spent a year studying this parcel. We've had the trees identified and located on a survey. We've had the topographic nature of the land completely studied. There's a scale model of the plat over here that our architect put together so that we could understand exactly where the slopes were, where the stormwater would go, and that kind of thing. Over the last year, we've looked at multiple ways to subdivide the property. And we felt that the scale along Skyline Road lends itself to maintaining 4 lots. And we were able to identify a way that would provide for those 4 lots to each have 100 feet in width at the location of developing the house, which we felt is really the most sustainable and the best way forward for that property. Subdividing it in smaller, only into 2 lots would mean a much larger development footprint and like a big giant beach house or something, and the amenities that go with that. And we don't think it fits the scale. Anyway, that's what we've come up with, and we have studied it for over a year to come up with this particular scenario. So,
I have nothing further with my witness.
Do you wish to cross-examine?
I don't have any questions for cross-examination.
Anybody have any questions for Mr. McClendon? Thank you.
I got one. When was the additional 100-foot added to the
in 1952.
52?
Yeah. The previous owners, Mr. Shepherd purchased it in 1952. He left it to his wife 20 years later when he died. 20 years later, she died, left it to their 2 daughters. The 2 daughters have died, and they left it in a trust. And we purchased it. That's the reason that when you see the old photographs, it was just a sand dune. There were absolutely no trees whatsoever. You look at the new ones, and it's covered in live oaks and tall pine trees. The fact that it's been owned by the same people for 70 years, 70 plus years, is the reason that it's been able to succeed with that vegetation.
Thank you. Mr. Burnell?
I'll call my next witness. I'll call Mr. Mark Bissell to the stand.
Afternoon.
Would you please state your name for the record?
Yes, Mark Bissell.
And Mr. Bissell, would you tell the board of adjustments here what your professional occupation is?
I am a professional engineer.
Any particular type? of
Oh,
engineer?
I'm a civil engineer.
And what exactly is a civil engineer? Just so that way, the room here understands.
Well, my firm primarily focuses on land development, engineering and surveying and so forth, related to the planning and design of what you can do with a piece of land.
And I am going to be asking the Board of Adjustments to accept Mr. Bissell as an expert, however, so I'm going to ask some questions here to attempt to qualify him.
Expert in what field?
The field of civil engineering and site planning.
Thank you.
So, Mr. Bissell, in terms of your occupation as civil engineer, how long have you practiced in this field?
I was first registered in 1982, so 40 years ago. Been practicing a bit longer than that.
And in terms of your current business, if you will, who do you work for? What's your company name?
Well, the company is Bissell Professional Group, and I am the senior principal of that firm. We have a number of engineers, technicians, surveyors, and so forth that work for the firm. And we do a lot of subdivision design work, a lot of planning and zoning work.
And how long have, I know you said you were licensed in 82. How long has Bissell Professional Group been around?
I came out here and moved to the Outer Banks in 1984 and went to work to manage an office called Triangle Engineering. And during the following year, I ended up acquiring the assets of that firm. So we've been practicing since 1985.
And the entire time has your practice since 85 or 84, 85, since you took over Bissell, has that been here on the Outer Banks?
It has.
What educational requirements are associated with your field?
It requires a four-year degree and then an internship and then a couple of exams to become licensed to practice.
Recall exams. How many degrees? You said you had a four-year degree. So what is your four-year degree in?
I have a degree from Duke University in civil engineering.
And how about license requirements? What kind of license requirements are associated with your field of work?
I'm a licensed professional engineer in the state of North Carolina.
Okay. And what's required for a professional engineer to obtain?
You
have to get a degree.
You have to have a four-year degree from an accredited engineering school, a minimum of 4 years practicing underneath the professional engineer, and you have to pass two exams, one on the fundamentals and one on principles and practice.
And you currently hold an active license?
And then your credentials are reviewed by a licensing board and they make a determination. Yes, I do have an active license.
And have you ever been sanctioned or anything of that nature as far as your license is concerned?
I had a minor infraction once upon a time, probably 20 years ago, which was a really unusual situation because we had a client who owned land at the state line, who had a surveyor that was involved. It was working on his Virginia side that he had to do some work on the North Carolina side that he sent to us, and we incorrectly relied on because it turned out he wasn't licensed in North Carolina.
Understood. Now, since the inception of your practice, kind of describe what your day-to-day functions and what you typically do on a day-to-day basis.
We do a lot of land development work. We will work on anything from a single lot, say a commercial development, a zoning case, or a commercial site plan, anything up from that up to, say, 1,000-acre planned community. And we do a lot of master planning and zoning. We do a lot of subdivisions, from small subdivisions and recombinations up to large major subdivisions.
And have you ever done any, or assisted in a client with subdivisions similar to these type exempt subdivisions? Maybe not directly on point, but similar?
Right, we do this kind of work pretty routinely.
Okay. And the projects that you're referring to, do they involve reading and interpreting codes of local government on a consistent basis?
They do. We do work in a lot of different local governments and a lot of different jurisdictions, and we have to be familiar with their codes and how to interpret those codes.
And do you work again with those local governments?
We do. It's kind of a bread and butter kind of thing. We review those codes on an almost daily basis.
And do you feel that you're competent to provide an expert opinion on the merits of this particular appeal?
I do.
At this point, I would ask the board, I'd like to tender Mr. Bissell as an expert in the fields of civil engineering and site planning.
Okay, it's approved.
And Mr. Chairman, just for the record, let's recall that if specialized technical or scientific testimony is needed, it can only be offered through an expert, and the expert must have a foundation laid, and that foundation would include his knowledge, skill, experience, training, and education. Is that based upon that, you're accepting him?
Yes, I am.
as an expert? Do you have any objection to
No
the
objection.
Thank you.
Thank you. Mr. Bissell, obviously in reviewing the plat, I can't help but notice that your firm was involved in preparing the subdivision plat. Were you yourself somewhat involved in the project as well?
Excuse me, for clarity, you mentioned the subdivision plat. Are you talking about the
The one that was
recombination plat?
denied, sorry, yes.
Not exhibit two. Got
The
it.
subject,
Right. The plat was prepared by Michael Barr, who is a senior licensed professional land surveyor with our firm, but I was involved in reviewing it.
okay. So then, safe to say you're familiar with the issues which are being raised today?
I am.
And during your review process of these particular issues, did you review the provisions of the town code that you believe to be subject to this appeal?
Yes, I did.
If you don't mind, can you kind of recite what provisions you believe those to be?
Right. There are really related provisions in both the zoning code and the subdivision ordinance that have to do with minimum standards of design regarding height, bulk, density, coverage, setbacks, and so forth. And some of those include section 36-202, the single-family residential district, section 36-90 on height, bulk, density, lot coverage, yards, and open spaces. Section 36-92 on reduction of lots or areas below the minimum, and so forth.
And
Chapter 30 subdivisions.
And I have not, or I did not tender because it's part of plaintiff's exhibit 1, that, well, the recombination plat was attached to the application. Does the board object to me just handing Mr. Bissell a copy in the event he does not have the same?
No, I don't, no objection. Do you object?
No objection. And what you're holding there, is this the same subdivision plat that your firm prepared, that you've been testifying regarding?
Yes, it is.
And you mentioned review of certain code provisions. I assume that you've reviewed also the town denial letter.
I did.
Okay. So do you feel like you have a grasp on why it is that the town denied this particular subdivision request?
I believe I did.
Okay. So in comparing your professional opinion and the town's professional opinion, can you describe to the board again what you believe to be so far as the validity of this particular subdivision request?
Sure.
Where do you stand on that?
Well, when I review the town code, I find the term used over and over again in both the subdivision ordinance and in the zoning code, the terms minimum requirements. Things like, for example, section 36-90 on yards and open spaces says, and lot sizes, it says these are minimum standards. You cannot have a lot that is narrow or a front yard that is smaller than what's prescribed. 36-92 states that yards or lots created shall meet at least the minimum requirements. And 36-202D says has a minimum lot width of 100 feet. And part 3 of that says a minimum front yard setback is 25 feet. But there is no place that I see that has a maximum width or a maximum setback or a maximum lot size or any thing of that nature.
And so in interpreting and in reading these provisions, do you believe that the subdivision plat that's been presented by my clients and denied by the Board of Adjustments, do you believe that it's in compliance with the town code? And if so, would you just explain why?
I do believe it, that it meets it because it complies with, it either meets or exceeds all of the minimum standards of the town code in terms of area, bulk, density, coverage, or not coverage in this case, but yards, setbacks.
And the issue here, as the town has pointed out in their denial letter, kind of explain your opinion on where the front yard setback could be measured from, is what I'll say.
Well, in the absence of the code prescribing a maximum setback, it appears that a developer can set the setback anywhere that they choose that makes sense as long as it exceeds the minimum. And in this case, where the setbacks have been drawn, they exceed the minimum. The lot widths at that point exceed the minimum.
And what are the lot widths?
The lot widths are,
Required lot widths.
required lot widths are 100 feet. And as this is drawn, you have lot widths, let's see, 101.4, 104.9, it looks like. Anyway, they exceed 100 feet.
And is it your testimony, am I understanding it correctly, your testimony is that the town's code has set a minimum setback, but
Exactly.
they've not set anything static or anything maximum.
Exactly.
And as such, the owner could be more restrictive on themselves if they so want.
Exactly. I would, look at it kind of like you have a minimum elevation for a building pad to keep it out of the flood zone. If that pad were, say, 8 feet as a minimum, and you built the pad to 10 feet to exceed the minimum requirement, that would certainly be in conformance with the code.
And again, you found nothing in the town code that set a maximum setback for lots.
No, I didn't.
Anything concerning a static setback, a required static, just across the board setback?
No, I didn't. And all I found was that you had to have 100 feet measured at the setback, and the setback has to be a minimum of 25 feet, but obviously can be more. And so, no,
So it,
I
again,
found no reason it wouldn't comply.
in laying the foundation for you as an expert, you testified that you consistently deal and probably dealt with Southern Shores planning department on many different occasions. When dealing with local governments, on whether it's a site plan or a subdivision approval, whatever the project that you're working on may be, without there being that type of explicit language, mandate something such as a 25-foot front yard setback. Is it your experience that, again, that a town would generally not allow the owner to be more restricted if they chose to do so, in the absence of such explicit language?
No, that's not my experience at all. And it's been also my experience that, that the local governments generally aren't able to impose additional restrictions that aren't spelled out in the code.
That aren't explicit.
Yes.
So again, Mr. Bissell, I'll just ask one more time for the record. Is it your professional opinion that the proposed subdivision, which was attached to the back of the Plans Exhibit 1, that subdivision complies with all facets relative to subdivisions within the town code ordinance, that it complies with all code provisions?
Yes.
And Mr. Bissell, before I turn you over, is there anything else that you would like to add?
The only thing I'd add is, in reviewing Mr. Haskett's letter, I think that, in my opinion, the second paragraph should read, in this case, all the proposed lots should have a minimum width of 100 feet measured at a line that is parallel to and at least 25 feet from the current right-of-way.
And for the boards, just because it's in front of them and you are reading and amending, what particular addition to that letter do you believe should have been made?
The words "at least 25 feet" rather than "at 25 feet."
Rather than mandating 25 feet.
Exactly.
Thank you very much, Mr. Bissell. I've got nothing more from my obvious witness. Board.
Don't leave yet. Don't leave yet. We like you. Could you stay up there a little longer to see what they?
They may have.
Sorry about that.
Questions on cross-examination?
No cross. Does anybody on the board have any questions?
The last statement that you offered in response to Mr. Varnell's question was a redraft of one sentence out of Mr. Haskett's letter. When you added the word minimum in front of 25 feet, which is what your redraft would have said had it been your draft, correct?
Or at least 25 feet, right.
Is that what the ordinance says? We're kind of ill-equipped here. We're relying on you to tell us what it is. I don't have it. But does the ordinance say minimum 25?
It does not.
And I can just walk through that.
Well, yeah, the ordinance says a minimum 25 feet.
But not as to this particular provision, the 100 feet. It says it as to the,
It says the minimum lot width 100 feet measured at the building setback line. And then the very next paragraph in that same section of the ordinance says the minimum front yard setback is 25 feet.
And then what is the definition of building setback line? Now, approach it. I'm not sure about it.
Yes.
I just wanted to hand him these codes so he's got them in front of him.
could you re-ask your question?
Absolutely. For clarity purposes, Mr. Bissell, let's walk through the provisions which I've just handed you. Again, they're Director Cybers prints off the website. 30-97 is the subdivision code. And it requires that again, all dimensional requirements of the RS1 or whatever zoning district you're dealing with when you're talking about newly created lots, that they meet the dimensional requirements of that zoning district, which now I'll turn it to you in 36-202B2. Could you read that for the board, please? And this is referring to the required width of any lot in some newly created lot.
D is dimensional requirements, and 2 says minimum lot width 100 feet, parentheses, measured at the building setback line, in parentheses.
Okay, and 36-202D3 reads as what when it comes to front yard setback?
As the minimum front yard setback is 25 feet.
Okay. And then going to 36-57, we've got the definition of building setback line, which is where the width must be measured from. What is the definition of building setback?
That means a line parallel to or concentric with the street right-of-way, establishing the minimum allowable distance between such right-of-way and the nearest portion of any building, excluding the outermost 3 feet of any uncovered porches, steps, gutters, and similar fixtures.
So it's measured from the building setback line, and it must establish the minimum allowable setback, correct?
Yes.
And the minimal setback is, for front yard setback purposes,
It's 25
is
feet.
25 feet. Now, taking that into consideration, I'll ask the question this way. Why do you believe that, because of the language that you just testified to and because of what's in the code, why do you believe there is no mandate or a static 25-yard front yard setback?
Because in every section or applicable section that we've looked at, the ordinance prescribes a minimum, but no maximum. The word maximum is never used.
And is it your professional opinion that in order for a local government to impose a maximum, that it must, or something static, that it must be explicitly stated?
I believe, that's my opinion, yes.
And do you, in those
And that's my experience.
And in those code provisions you just read over, do you find that any such mandate exists?
I don't.
Mr. Holland?
And board, I printed a ton of copies of the code provisions, if y'all want me to hand, I thought they were within the packet, I'm
Please.
sorry.
Please.
The variance is what I'm used to, so I apologize for that. I do have copies. Well, may I approach?
Yes.
They have to be split up. I got 3 copies here of each code provision.
I'll share.
Mr. Holland, do you
I
have?
don't have any questions for cross-examination.
Okay. Is there any questions from the board? If there's no questions, guess what? You can leave now.
Now I can.
Now you can leave.
Subject to being recalled.
Yes.
Ready for next witness? Board?
Yes.
Okay. I will call Mr. Adam Ward to the stand, to the podium. Would you please state your name for the record?
Adam Ward.
And Mr. Ward, are you the applicant on both the subdivision, or in other words, I'll say it that way, did you deal with the town in proposing this subdivision?
Yes,
And are you also the applicant on this appeal?
yes, I am.
How did you come to be involved with the proposed subdivision?
In the summer or maybe late summer of 2021, the owners of the property approached me and my business partner to help them with site planning strategy for how to develop this piece of property
How long have you been working on this project?
for just over a year. We started last September.
How many different proposals, out of curiosity, did you fathom on?
Site plan schemes?
Yeah.
10, 15, 20, I'm not really sure. I mean, there were a lot of different schemes that we looked at and studied the
Been
site.
working at it.
Yes,
It's a good hard work.
yes.
Board, I am going to ask that you guys accept him as an expert in the fields of architecture and site planning. And I will.
Want to lay the foundation?
Yeah.
I'm gonna lay the foundation. I'm
Yeah.
just telling you why I'm about to go down this lineage
Okay.
of his educational history, because otherwise you probably wouldn't care. So, what is your professional occupation?
I'm a licensed architect in the state of North Carolina.
And how long have you practiced in this field?
I've graduated in 2013 and took my first job for an architecture firm in 2014 in January, and I've been working in architecture since. I've been licensed in North Carolina since 2017.
What educational requirements are associated with an architect?
To become a licensed architect, you need to have a professional architecture degree that can either be a 4-year bachelor or 5-year bachelor's or a master's of architecture.
And what degrees do you have?
I have a master's of architecture from NC State.
And obviously a 4-year degree under that.
Yeah, I have an unrelated 4-year degree and an unrelated law degree.
How about licenses though? How does licensure work in the field of architecture?
So to get licensed, when I did it, it's pretty much the same now, but when I did it, to get licensed, you had to have an approved degree from an accredited university. Then you had to intern under a licensed architect it was measured by hours, but it roughly translated to about 2.5 to 3 years. And then you had to take 7 licensing exams, one including, or they were arranged according to different areas of the field, one including site planning and design.
So you hold one license, but there's several different fields, of course, of architecture. And you kind of have to hit all the nodes.
Yeah.
Like a lawyer.
Yes.
would do the bar exam.
Yes.
And how long again have you been licensed as an architect?
For 4.5 years, I believe, in North Carolina, and that's the only license I hold. So 4.5 years, I believe.
And have you been practicing, well, maybe even prior? How long have you?
So I've been working in an architecture firm because I had to intern under a licensed architect for 8.5 years. But some of that was in North Carolina, some of that was in California.
Understood. Since you began your practice or began practicing in this field, what are your day-to-day functions and typical tasks? What does an architect do?
Our day-to-day functions are to help clients. I've mostly worked in residential architecture, some small commercial, but our day-to-day tasks are to help clients with anything from site planning to designing structures, to helping them figure out programmatic elements of a project. But if we start with a client who has a fresh piece of land, we start with site planning, and then we go from there and we work on schematic designs for the structures that would go on the property.
Is it fair to say that a project such as this, that you've been retained for by the landowners, is this a project that you would typically work on, or is this outside of your availability?
No, it's a pretty typical project. We're contracted with them in a unique way that we're working specifically on site planning with them now, with the goals once we have approved subdivision that they'll retain us to help design the houses as well.
And in any given project, or the majority of your projects, do these involve, as I asked Mr. Bissell, reading and interpreting local government codes?
Yes, certainly. Either for site planning purposes, reading the code, the zoning code, setbacks, easements, things like that, and then for the actual design of houses, the building codes.
And do you work with local governments on these site plans?
Yes.
For example, on a consistent basis?
Yes.
And do you feel after, let me ask this first, actually, you're the applicant, so it's kind of a default type question, but you're familiar with the merits of what's going on, correct?
Yes, that's correct.
And do you feel you're competent to provide expert opinion in the field of architecture and site planning regarding this particular field?
Yes, I do.
At this point, I would ask to tender my witness as an expert in the field of architecture and site planning. No objection.
Okay, yeah,
Thank you.
approved.
So, Mr. Ward, I'm going to actually shift away a bit from the code interpretation side of things as far as the subdivision ordinance and dimensional requirements and where you're making setbacks from. And we've heard Mr. Bissell's opinion on that. Before I do, I will ask, have you reviewed the provision subject of this appeal that Mr. Bissell testified to?
Yes, I have.
And again, that's in your general nature as an architect to do the same.
Yes.
And do you believe that those code provisions that we're discussing here, do you believe that the proposed subdivision complies?
Yes, I believe that the recombination plan that we submitted applies and meets all the code
I
requirements.
don't think that surprises anybody there since you're the applicant. So I'll just ask you, why?
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 Well, because we meet all of the minimum lot sizes, we meet the minimum requirements that are set in the code for a new lot, and particularly to the language of the denial, we believe that the code sets a minimum front yard setback at 25 feet, but as long as we meet that minimum, we can surpass it and have a setback that's 26 feet or 40 feet or 100 feet, because the code doesn't set a maximum.
So that was going to be my next question. In reviewing the code, did you find anywhere where it was mandated that a static or maximum front yard setback be or rendered by the town?
No,
Okay. And in your experience, and then I want to get off this code interpretation thing. In your experience with working with local governments, is it usual that a local government would not allow a landowner to be more restrictive on themselves in the event they chose to do so?
no, I don't think so.
And would that go for setbacks?
Yes, for setbacks, yeah.
Okay, thank you very much. Now, as far as the RS, let me ask that, what zone is are these particular parcels in?
It's an RS1 residential zone.
And for the RS1 residential zone, have you had a chance to review the code provisions concerning the spirit and purposes and intent of that particular zone?
Yes, I believe I have.
Do you believe you're familiar enough with them to provide an opinion on the spirit and intent of the RS1 zoning district?
Certainly.
Would you do so, please?
Yes, I believe that the spirit and the intent of the code, especially under the subdivision codes and the purpose listed in 30-5, is to provide orderly layout of the land, to make sure that traffic flow is protected, and to make sure that we conserve the environment and the spirit of the town of Southern Shores. Essentially, I believe that the intent of the code is to prevent Southern Shores from growing too large or having properties that are too big. It's to respect the town and as it is, and to build in a way that is cohesive with the existing town.
And is that an interpretation, or does 30-5, the purposes of the RS1, does 30-5 actually recite those items?
It doesn't recite specifically, it recites,
Do you have that?
I don't have it in front of me I don't know if you have a copy of it or not, but I have,
Or if you give me 1 second, I apologize. Actually, attached to plaintiff's exhibit 1 attached to my legal opinion that was rendered as part of this application. I have the quoted language from 30-5 for your reference, if you want to look into that. I am going to hand up here, this is the legal opinion that was attached to the exhibit, just so Mr. Ward has an actual copy.
Mr. Hollow?
That's okay.
You're familiar with, okay.
Would you read that provision concerning purpose and intent of the RS1, please?
Yes, it says the RS1 district is established to provide for the low-density development of single-family detached dwellings in an environment which preserves sand dunes, coastal forests, wetlands, and other unique natural features of the coastal area. The district is intended to promote stable, permanent neighborhoods characterized by low vehicular traffic flows, abundant open space, and low impact of development on the natural environment and adjacent land uses. In order to meet this intent, the density of population in the district is managed by establishment of minimum lot sizes, building setback and height limits, parking regulations, and maximum occupancy limits for single-family residences used as vacation cottages.
So have you had a chance, Mr. Ward, to consider alternatives or what, if you will, could be built on the particular lot? On the parcels, but I'm gonna ask this in 2 particular ways.
Okay.
Have you examined what could be built using the particular subdivision proposal, using 4 lots that you guys are
Yes.
asking for? How about the town's interpretation, using their interpretation?
So it's my belief that,
Subdivision.
yes, it's my belief that if we follow the town's interpretation, that,
And what would that look like, by the way? The town's interpretation.
okay, the town's interpretation that the front yard setback, that the minimum lot width of 100 feet must be measured at precisely 25 feet back from the front property line. That in order to have that requirement and the front setback line being static at 25 feet, that the 2-acre, almost 2-acre parcel of land would only allow for 2 lots to be developed on it, as opposed to 4 that we've drawn.
And at this point, I'm going to hand up 2 exhibits, actually. I'm going to have him qualify these things, and then if they're accepted, I think that'll provide a better illustration of what we're discussing here when we're talking town interpretation and result versus our interpretation and result. Jay, we're on 2, is that right? Number 2.
I classified the 3 sections of the ordinance as plaintiff's exhibit number 3.
So
So you'd be
4.
on number 4.
These things are marked plaintiff's exhibit 4 and 5. Did you prepare these particular, actually, you tell me what they are. How about that?
Okay, they were prepared by my business partner, but I reviewed them. I'm sorry? Okay, go ahead. So they're,
What are they?
they are 2 comparisons of what the parcel would look like subdivided as we've proposed in Exhibit 5 and subdivided into 2 lots in Exhibit 4.
And again, this was prepared by your firm.
Yes, this was
Correct.
prepared by my firm.
You have intimate knowledge of this.
Yes.
Given that, Chairman, I would ask to tender plaintiff's exhibits 4 and 5 in the evidence.
Any objection, Mr. Hollow?
No objection. I'm going to hand these up, if I
Yes,
may.
please.
Okay, got it. I want to make sure I have 4 and 5 right.
4 and 5.
Put it on that front too. That's 4, that's 5. There should be no copies for everyone.
Mark
You need one more?
it. No, I told him to mark it. This is 5.
Just let me know when everyone has it in front before I. Okay. What's marked as plaintiff's exhibit 4? Describe that document, please.
So plaintiff's exhibit 4 shows the parcel of land recombined into 2 lots. The dark area shows the buildable area that's defined by the setbacks set in the code. And those both have 25-foot setbacks because the lots are wide enough at 25 feet to be 100 feet wide. And then the white area in the middle is the coverage allotment for the lots, or a rough approximation of the coverage allotment. And then exhibit 5 is the same. Okay, sorry, yeah.
So, in your professional opinion, I mean, this has not been submitted, I understand.
Certainly.
But in your professional opinion, this is what would result in a recombination, if you will. This is what you could do if you abided by the town's interpretation.
Yes, yes,
That's what plaintiff's exhibit 4 is an illustration of.
yes.
Understood, okay. Now, please continue to exhibit 5.
Okay, so exhibit 5 is showing what we've proposed, a 4-lot solution that meets, in our opinion, all of the requirements of the code. And what it shows is that we've got, in the dark area again, is the buildable area set by the side and, or the side and rear setbacks as written in the code, and as well as the front yard setback that we have set further back than 25 feet to meet the minimum lot width. And as you can see from it, it produces more concentrated buildable areas on the lot, preserving more of the lot, for more of the overall acreage from construction.
So having read and interpreted and understood the purpose and intent language that you recited verbatim earlier, just describe in your professional opinion whether plaintiff's exhibit 4 or plaintiff's exhibit 5, 4 being the town's interpretation, 5 being our interpretation of the code, which particular subdivision would better comply with the spirit and purpose of the zoning ordinance?
So in my
Of the RS1 district.
certainly, in my professional opinion, I believe that the exhibit 5 that we have submitted more fully conforms to the intent of the code in that it creates a subdivision that fits the neighborhood, that's respectful of the neighborhood, that would produce smaller lots that meet the minimum, that are closer to the neighborhood. The challenge for us was that most of the lots in the neighborhood don't meet today's code. They're smaller than today's code. So we wanted to design something that fit in the neighborhood and was respectful of the town and the subdivision, but still meeting today's code. So that's how we arrived where we are. And so my professional opinion is that what we have designed, it allows us to build 4 houses that are more comparable in nature to the size of the existing houses, that it will fit the context of the neighborhood and the fabric of the neighborhood. Whereas in the other, in exhibit 4, if we do 2 lots, the buildable area is much larger and we could build in a lot more spaces, which means that we could have larger footprints possibly. But also it would not fit the fabric of the neighborhood as well.
What about the disturbance of topography or saving of natural topography?
So that, ultimately, that's what we spent the last year trying to do, is trying to create a plan that would allow us to be as observant of the natural topography and the trees that exist. And, I believe that our plan allows us to do that because we're going to build 4 smaller structures that we can nestle into the existing site. And we can be cognizant of how, the taking down as few trees as possible and maintaining the topography as it exists as best as possible. Whereas if the 2-lot solution, in my opinion, would require the construction of the largest possible house the code would allow in order to make it a profitable venture. And that would probably result in more clearing of space and maybe more site work than if we nestle 4 houses into spaces that the site kind of allows for it already.
Larger development.
Yes.
Did you review any other documents pertinent to the goals and intent of Southern Shores in this particular zoning district or across the town?
Yes.
Okay. Is the 2005 or January 2006 is the date, the Long Range Planning Committee report, is that one of those documents?
It is, yes.
May I approach the witness?
Yes.
Handing you what's marked as Plans Exhibit 6. That particular exhibit, it is as it's titled, Town of Southern Shores 2005 Long Range Planning Committee Report.
Excuse me, Mr. Hollow, is this okay? Do you have
Sorry.
any objection?
Yep.
I'd like to see a copy of it.
Yeah, oh no, I was there now.
Thanks.
What I was actually going to say is the entire printer, right from the website.
It was show my.
Okay,
Thank you,
Proceed.
Chairman. I apologize. I jumped the gun. So, to verify this document, what exactly is it? You said it's a document you reviewed, so.
Yeah, so it's a report that the town of Southern Shores prepared in 2005, or it's dated 2005, for their long-range planning goals.
Does this plan apply across the town?
I believe it does.
Okay. Does it apply, at least, did you find provisions that are applicable to the RS1 zoning district?
We looked primarily at this document to gain a better understanding of what the town's goals were when it came to planning and development. And so we looked particularly at the document, at the town's mission and the town's core values in trying to develop a site plan that was responsible and reflective of the town's goals and missions.
And it's your testimony that that's essentially what this document establishes. In your professional opinion in reading it, it establishes those goals.
I believe so, yes.
And to your knowledge, I mean, you obtained this document from the town's website is what I was told. To your knowledge, this was produced by the town?
To my knowledge, it was.
I've asked to tender that into evidence as Plaintiff's Exhibit 6,
yes, it is 6.
and I've got copies for everyone. May I approach?
Yes.
Mr. Ward, what I'm going to ask may require you to look in. The board very well may have questions, but now the document's in front of everybody. Do you feel that there are any provisions within this long-term planning document that are pertinent to today's proceeding?
Yes. I think the mission statement at the beginning and the core values are something that we looked at when we did our analysis of the site plan and informed the site plan that we presented to the city. Or not, I'm sorry, the subdivision that we
How does
presented.
this subdivision, correct, how does this subdivision, in your opinion, better carry out this intent?
Certainly. Well, in the mission statement, if I can read it, it states that Southern Shores carefully controls growth and development so this unique community remains a most desirable place to live and visit on the Outer Banks. family-oriented, tranquil, friendly, environmentally sensitive, and full of beautiful natural attributes. So just in that statement alone, you know, our goal and the owners, the property owner's goal of this project has been from the beginning to develop a property that respects the neighborhood that it's in, that fits within the fabric of the neighborhood, that is tranquil, for lack of better words, that, you know, we want to leave as much of the trees as we can and preserve the natural beauty of the site and be environmentally sensitive when we plan for drainage and septic fields and any of the construction that we would need to do for it.
And back to plaintiff's exhibit 4 being what could exist as a subdivision using the town's interpretation, and plaintiff's exhibit 5, which is your proposal on subdivision. Which of the proposed subdivisions, in your professional opinion, better complies with the long-range plan for subdivision?
In my opinion, it's the one that we submitted, Exhibit 5.
And is that for the reasons that you recited already?
Yeah, I think that it respects the site and the natural beauty of the site, and it fits within the fabric of the neighborhood and is cohesive with the town and the neighborhood that it fits in.
And have you had a chance to review surrounding areas or lots within Southern Shores, particularly to compare, you know, how the lots created by your subdivision would reconcile with the size of currently existing lots?
Yeah, yes, we have.
Did the models that I handed up as plaintiff's exhibit 4 and 5, did they have any of that information on there?
They do have, there is a chart on there, let me get back to it, that looks at the, on Exhibit 5, I guess it's on both Exhibit 4 and Exhibit 5. There is a chart that shows the parcels, the 43 parcels on Skyline Road in particular, and it shows the square footages of the existing lots. And they range anywhere. The largest one is 38,000, but it is owned by the town, I believe, or by the Civic Association. That's correct. But it is 8,000 square feet larger than the next largest lot. But the average lot size is about 16,000 square feet. If you remove the extreme lots and do an average, it's about 14,000 square feet. So the lots we're proposing are all meet the minimum 20,000 square foot lot requirement. So they would be among the larger lots on the street as we're proposing them.
Okay. How about using the town's analysis?
If we use,
Given all this excess land in the back.
yeah, if we use the 2-lot solution, then we would have the 2 largest lots on the street. They would be over 40,000 square feet each, making them the 2 largest. And if you take out the 38,000 lot, they would be or the next largest lot would be 3/4 of the size of the lots that we had. And if we, and they would all be, you know, more than double the average lot size on the street.
So then is it
Nearly triple.
fair to say then that the lot, using your subdivision proposal, there's going to be smaller lots created? Is that what you're taking?
Yes, smaller lots that fit and in with the fabric of the existing neighborhood, but still meet today's code.
Mr. Ward, is there, before I unleash it, is there anything else you'd like to add to your testimony?
Only that, I don't know if it was clear enough. Actually, no, it was clear enough. I don't think so, no.
There is a model behind you
Yes.
there. Before we even get into the evidentiary, what is that model?
So that is a site model that we built early on in our process so that we could look at the site and get a better understanding for how the topography of the site slopes and where ideal locations for a site plans might be. And it also shows all of the trees on the site that were included in a survey that the homeowners had done
And
last summer.
It's a bit unusual, but I'll ask the board, we're not here to review a site plan. But if we have this model here, as he testified to, it is one of the models that he's created. If you guys would like to see that, we will certainly introduce that into evidence with your admission.
We're going to take a break shortly. So at the break, they can, whoever wants to go over and look at
Understood.
that, I think that would be an
But to make it
appropriate
part of the
time.
record,
Yeah, we
Go ahead.
really need to either admit it or not look at it.
and I would say if we admit it, then they could go over during
Correct.
the break
Without
Oh.
with a
discussion.
simple
Yeah,
admission.
without discussion, yes.
Then I would tender that as plaintiff's exhibit 7.
So,
7. Okay. Is there any objection?
No objection.
That'll be 7. And when we take the break, without discussion, you may go over and take a look at the site plan, okay?
On that break, this is my last witness, and I am finished questioning.
Can-
So,
can-
or did you, go ahead.
Yeah, can I just add one thing about it? So this is a working site model that we have been working on. So when you do take a look at it, we have shown the lot lines as proposed in our recombination, the application. But you will see there are lots of different squares and things on there because it's a model that we have played around with. So there's no real site plan on it. But you will see some locations where we thought about over the last year, the potential placement of properties, of
Of
houses.
structure.
Yeah.
Now I rest.
I just got a couple quick questions.
Yes.
Okay.
In your opinion, would there not be sufficient area to create 3 lots instead of 4 and still meet all of the zoning requirements?
I don't think so. I think that if we measure at 25 feet back across the entire parcel, it's less than 300 feet.
Okay, even if you reworked the parcels as they're currently shaped and made it to where the middle 2 parcels were combined into one and were one larger parcel, it still wouldn't make it 100 feet?
Yeah, no, I don't think so. I think if you drew a line that so the code says that the line needs to be parallel to the front property line. And if we looked at the entire parcel as a singular piece of property and drew a line 25 feet back from the front property line and measured that line, I don't think it measures 300 feet.
Have you actually gone through any simulations to see whether or not it would actually make?
Yes,
get
yes, we
100 feet?
have. I don't remember off
Did you
the
bring
top.
any of those with you
I
today?
did not. I don't remember the number off the top of my head.
And do you happen to know how many lots in Skyline were approved before this ordinance was adopted?
How many of the lots on Skyline Road
Was
were
that something you
approved?
looked into?
Yeah, we did look into that. It's in the packet, the exhibit that I believe there's some information in there. Do you have a copy of that with you? I'm sorry? Yeah, it's exhibit, or
D.
it's D in the appeals application. I believe that page has that information on it.
And were a
But I
number
don't
of
have it
those
in front of me.
approved before the town was incorporated?
I'm sorry?
Were a number of those approved before the town was incorporated?
I believe a number of those were on the original plat that the property, that the 4 lots that the 4 lots that exist as they are, were drawn on.
I don't have any other questions. Thank
Okay.
you.
Does anyone have any questions?
Yeah, if you don't mind,
Sure.
on page 41 of the long-range planning, you have that in front of you?
Okay, yeah, let me find it. 41,
41 under growth, just read what that says.
okay. Oh, sorry, that's 42. Growth. So this is Southern Shores 2005 Long Range Plan Opinion Survey Written Comment Summary. And it says growth, keep it simple, too much, too fast, slow it down, keep it like it was, no more mini hotels, clear cutting, stop commercial, stay family oriented, stop playing to wealthy investors and tourism interests. Change is not necessarily progress.
Thank you.
Does anybody else? Go ahead.
Thank you. On the original subdivision plat, map
Yes.
book 3, page 91, there were 4 lots, 8, 9, 10, 11.
Yes,
Would the appellant be entitled to go ahead and have those 4 lots?
it's my understanding that they cannot.
Do you have knowledge as to whether those lots were combined at some point and the dividing lines between them were vacated? Is that the reason they're now subject to this new ordinance?
Yes, well, they're subject to the new ordinance because the property owners would like to build on them. And it's my understanding that the town would not let them build on those lots because they don't meet today's minimum requirements, size requirements.
Thank you.
I have a question also.
Certainly.
Earlier, you were talking about the spirit.
Yes,
Tell me, could you explain why you do not include the spirit in the dimensional requirements, number 3? Why is the spirit of the town's code not, you didn't include that? So you're including the spirit in, earlier you talked about the spirit.
okay,
And D3, where it says minimum front yard setback, 25 feet, and why are you not including the word minimum as the spirit? In other words, there's a letter of the law and the spirit of the law.
certainly,
Basically, and you brought up the spirit of the law.
sure.
Do you
So-
think the spirit of the law was 25 feet?
I think the spirit of the law was that we create, or we didn't create, the town created a minimum setback of 25 feet to provide a buffer from the front of the property line and from the street to where buildings would exist. And so the spirit is about creating that buffer, in my opinion. And so if we have 30 feet, we're only expanding that buffer and further validating or the spirit of creating a buffer. Like, I feel like if we were asking to go 10 feet, that we would be not in harmony with the spirit if we were trying to do a 10-foot setback. But because we're being further restrictive, we're furthering the spirit of the buffer of the front yard setback.
So then the spirit is kind of a moving thing. Because you said 10 feet doesn't work, but 25 feet will. So is the spirit a moving?
No, I believe that the language of the code states that there is a minimum setback. And that if we're to try to understand why there is a minimum setback, why that was the language that was chosen by the town when they created the code, it must be that they wanted to maintain space between the right-of-way or the front property line and any buildings. And so that would be the spirit, that they wanted at least 25 feet of space. And so if we were to inhibit, or if we were to encroach on that 25 feet, it would be contrary to the spirit of creating a buffer. But if we were to have a 40-foot setback, then we would just be furthering the spirit by creating a larger setback and creating a larger buffer to protect from overcrowding on the street or whatever the intent of the front yard setback was. Does that make sense? Or am I making sense, I guess?
Basically, kind of what you're saying, the spirit of, and the buffer is a movable, it's not static.
I mean, I believe it's not static because that is the language of the code. But if we're talking about setbacks in general, the spirit of setbacks is to create a buffer of space from your property lines to keep buildings from being too close to the property lines. And those could be for aesthetic reasons. They could be for fire protection, so fires don't spread from one house to another. But if there is a spirit to that, it is creating a larger buffer would be better than creating a smaller buffer. The buffer is there for some reason. For some reason, towns have chosen to put these setbacks in. And if we're creating a larger buffer, then it's not harming the intent and the spirit. It's my opinion.
Is there any other subdivision in the town that has a floating front setback?
Well, depending on the zone, whether you're RS1 or RS2 or a different
Well,
zone,
RS1.
they all have minimum setbacks. They may not be set at 25 feet. They could be set at another number. And I don't have the code in front of me right now, so I can't tell you exactly what that number is, but they all state front yard setback, minimum front yard setback, and then some number. And so in my opinion and in my belief, yes, they're all floating. There's a minimum, but they can be larger.
Is that, but isn't the 25-foot setback the point at which the lot width is measured?
So the code requires that the lot be 100 feet wide at the building setback line.
Right.
And when you look at the definition of the building setback line, the building setback line just says that that is a line parallel to the street that must be a minimum of the required, and the front yard setback is a building setback line. Right? We have the building setback line is a broader category that includes front yard setbacks, rear yard setbacks, side yard setbacks. And then in the code for each zone, it sets a minimum setback. And for RS1, it sets the minimum setback of 25 feet.
So if the town went with this floating setback line, then that would be set a precedent for,
I think the precedent's already been set. I think that there are already houses that don't have their front yard setback at 25 feet. I don't believe that there's anywhere in the code that requires the front setback line to be static at 25 feet. That's
but the lot has to be 100 foot.
at the building setback line, but the building setback line has to be a minimum of 25 feet. So a front yard setback line that is 30 feet wide meets, and is 100, if the lot is 100 feet wide at 30 feet back, then it meets the minimum setback width at a front yard setback that is at a minimum of 25 feet. It's greater than 25 feet, so it meets the minimum requirement.
So does this then open it up to flag lots?
Not necessarily. I mean, it's not opening anything up. It's just interpreting the code as it is written, that there is a minimum setback and not a static setback.
Anybody have anything else?
Redirect.
cannot do.
Yes, redirect. Yes.
Just slightly. Let me try to clear up.
Mr. Varnell, we've had a member get up and walk out. Right?
Yes. So why don't we take a break?
Oh, yeah, I didn't even know.
Yes.
I was involved.
So I would not
Please.
want your important points to go.
No,
missing
please.
Yes.
for 1:54.
Honestly, didn't even, I couldn't see him behind the screen.
Okay.
I didn't know he got up. All right,
Yeah.
good.
We'll take a 10-minute break,
That's
okay?
fine.
All right, great. Thank you.
All right, sounds good.
You want that one?
How long did it take you to get there?
Everybody ready?
I am. Mr. Ward's headed back up.
Okay.
And I won't take long. I thank y'all for indulging us.
It is 2:45 and we're going to reconvene the hearing.
Mr. Ward, on redirect here, I just wanted to try to see if maybe I can rehabilitate you a little bit on some of the questions that
Sure.
were asked. The idea of intent and of the RS1 zoning district. And the intent's going to be disrupted and or a precedent is going to be set if this, as it was referred to, a floating setback is created. We know that we don't believe there's a floating setback for the reasons you said, but are there other restrictions in play that if a more restrictive setback than 25 feet was used, does that property have other restrictions that are going to constrain what you could build on that lot?
Certainly. Every lot is going to have a rear yard setback and side yard setbacks. And so if a property owner chooses to set a front yard setback further back than 25 feet, they're only making their buildable area smaller. And so they're not creating an opportunity to create something that doesn't fit within the scope of the town. They're just putting restrictions on themselves and saying, look, now I can only build in my lot in this smaller area than this larger area. And so it's not.
And do you think, is it fair to say in your professional opinion, that's why a usual landowner is not going to want to deviate from the minimum?
Certainly. I think a usual landowner is going to, if the lot is going to set their front yard setback as close to the front as they can, so long as their lot meets the minimum width requirement.
Okay. And final question. So we've focused on, and a board member was discussing with you the fact that it does in the code, front yard setback, minimum 25 feet. What would your opinion be, professional opinion be, if the code read front yard setback 25 feet, removing the minimum?
If you remove the word minimum, my professional opinion would be that there was a static front yard setback at 25 feet, that your front yard setback had to be 25 feet back from the front property line, and that's where you'd measure your lot width.
And this code does not have that, correct?
It does not.
No further questions.
I don't have any other questions.
Thank you.
Thank you.
And you can sit down.
All right, thank you.
Do you have any further witnesses?
I rest my whole entire case.
Okay. At this time, Mr. Hollow?
Thank you very much, Mr. Chair. At this time, I'd like to call Mr. Haskett to the stand. Okay, Mr. Haskett, can you please state your full name for the record?
Wesley Taylor Haskett,
Okay, and what's your current occupation?
Deputy Town Manager, Planning Director for the Town of Southern Shores.
And about how long have you been in that position?
It'll be 13 years in November.
And as part of that position, do you consider these recombination requests on a pretty regular basis?
A few a year. I wouldn't say it's a regular basis.
Okay. And you decided to deny the application in this case. Could you explain the reasons you denied the application?
Yes, sir. The applicant received a letter from me, a denial letter, basically explaining that the recombination request was being denied due to the fact that it could not satisfy the requirement based on my interpretation of the town's lot width requirement of 100 feet at the building setback line. The lot width requirement is established in section 30-97. The zoning ordinance requirements are tied into the subdivision ordinance. Even though this is a recombination, it still has to meet the requirements. So the main reason why their application for this recombination was denied was due to my interpretation that it does not satisfy the town's lot width requirement of 100 feet, which I believe measured from the building setback line, which is 25 feet from the front property line. It's my belief that the building setback line is a point of measurement. It's a line that establishes the minimum distance. That's where you draw the line. That's where you draw the minimum distance, not beyond 100 feet. Section 202-B3 in the zoning ordinance establishes the front yard setback as minimum 25 feet. Again, you have a line establishing that distance. So it's based on what I believe to be a point of measurement.
Okay, and while we're on this denial letter, Mr. Bissell suggested earlier that he thought that the language should be changed in the second paragraph that says, all of the proposed lots should have a minimum width of 100 feet measured at a line that is parallel to and 25 feet from the current right-of-way. He suggested earlier that that sentence should have read that the proposed lot should have a minimum width of 100 feet measured at a line that is parallel to and at least 25 feet from the current right-of-way. Can you explain why you didn't include that at least language in your letter?
The ordinance doesn't say at least.
Okay. And this 2005 long-range planning committee report, to your knowledge, has the town, first of all, to your knowledge, is this any kind of official document that is followed, in terms of an actual policy of the town right at the moment, or has it been replaced by anything since 2005?
The current land use plan, the town's land use plan that's in effect was adopted in 2012. It was accepted by the town, and it may have been policy at one point, but it's my belief that it's not currently in effect.
Okay. And there's been a lot of discussion about the interpretation of the ordinance today. When you denied this application, did you deny it based on what you thought the intention of the ordinance was, or what you thought the purpose of the ordinance was, or did you deny it based on the actual language of the ordinances?
The language found in section 36-202D.
And again, I know we've been over this and it's probably getting a bit repetitive to the board at this point, but 36-202D dimensional requirements, subsection 2 requires the minimum lot width to be measured at 100 feet at the building setback line. Is that what you understand it to read?
Yes, sir.
And do you have a copy of the definition of building setback line in front of you?
Not a copy, but it's in the letter. That was included in the denial letter.
Do you have that up there with you?
Yes, sir.
Would you read the definition of building setback line?
Yes, sir. It is defined as a line parallel to or concentric with the street right-of-way, establishing the minimum allowable distance between such right-of-way and the nearest portion of any building, excluding the outermost 3 feet of any uncovered porches, steps, gutters, and similar fixtures.
Okay, and again, the 36-202D2, it doesn't say a minimum lot width of 100 feet measured at some point beyond the building setback line. It doesn't say that, does it?
I believe it says at the building setback line.
Okay. And last thing here, there was some discussion earlier about some of the policy purposes of the town and some density discussion and how the recombination, if approved, would meet the spirit. What are your thoughts on the whole density argument earlier? Do you believe there would be, more of a density issue if this recombination request were to have been approved, or?
Well, not knowing what the septic capacity would be for the structures, if either their proposal was approved or another proposal was approved. But if we were to assume that it was a 14-person septic capacity, which is the maximum allowable in the town, if you have 4 houses with 14-person septic capacity, that's quite a big difference in density than 2 lots or 3.
Okay, have you had any other recombination requests in the past that you've dealt with?
Yes, this is
Specific to this lot?
specific to this lot. I believe when it was for sale, I was contacted by several different realtors that were invested or representing prospective buyers that were interested in the property. And whenever I was called and asked questions, usually the question is, how many lots can I get out of this property? And my answer was, I do not know, but I did quote or cite the lot width requirement and the 20,000 square foot minimum lot area requirement. And when I quoted the requirement, I refer to section 36-202D, where it states that the building setback line is 25 feet from the front property line.
So in other words, your conversation with the prospective buyer, the realtor at that time, was based on the exact language of the ordinance and the same interpretation that you applied in this case?
Yes, sir.
Okay, and for other recombination requests that have come up in the past involving these definitions, have you always applied the same exact definition, the same manner to recombination requests?
Yes, and the first I recall was from 2014. There was a inquiry from a local surveyor about a piece of property on Ocean Boulevard, and they wanted to create 2 flag
Objection,
lots.
you say.
Sustained.
Okay, have you applied this exact same language to other recombinations in the past? Recombination requests in the past? Have you applied the same interpretation to other recombination requests in the past?
Yes.
Okay, and did those result in denials for the same reason that this application resulted in a denial?
Yes.
Okay, I don't have any further questions for Mr. Haskett.
Chris?
Just a few. Mr. Haskett, are there, outside of the provisions we've been discussing today, namely setbacks, I suppose, are there any other provisions that you can think of that set minimums?
There for yard, it does say minimum. For lot width, it does say minimum. None else come to mind at the moment.
And for those yards and lot width minimum, if an owner came to you and said, okay, I'm gonna, further constrain myself in this subdivision and make my lots as minimal as possible. I mean, could they deviate, I guess is what I'm trying to drive at, from these minimums? I'm trying to figure out why setbacks and the use of the word minimum is different from any other provision in your code and how it's applied.
Another one that did come to mind is minimum lot size,
Mhm.
20,000 square feet. So I don't understand the question though. Can you repeat the question?
So I'll go for it. That's okay. In general zoning, oftentimes I represent KW, so I hear this whole meet or exceed standard a lot. Why is that not applicable to this particular scenario? And what I mean by that is this particular proposal must meet and or exceed the regulations of the particular zoning district. That's a pretty general and principal term in zoning. Why doesn't that apply here? Because if it did, they do exceed the requirements.
I think that if it did meet or exceed, it would be approved or would have been approved. In my opinion and my interpretation clearly is that it doesn't meet or exceed.
But how could you exceed? Wouldn't that only be to be more restrictive
In this case,
with the setback?
it's not met because I believe the building setback line is a unit or point of measurement. It's a line that is established with the front setback at 25 feet.
Two quick ones here. Just because I heard you use the word believe. As far as the testimony regarding potential density on the lot itself, are you certain as to that? Can you definitively say that your testimony is that they could produce a more dense development using their proposal?
I'm saying that if you were to go to the maximum of 14-person septic capacity in each home, multiply 14 times 4 versus 14 times 2 or 3. And that density number of units per acre, people per acre is higher.
But a plan such as that's not been presented to you yet, correct?
Or the exhibits that you provided or that were shown earlier show 4 potential homes versus 2.
Right, but you've not reviewed
I have not
any
received,
of the site plans because we don't have subdivision.
no, sir, I have not received any, I have not seen any building plans for this specific property.
And same deal here because of the 2005 land long-range planning document, you said you didn't believe. Are you absolutely certain that this long-term plan has been amended and/or is no longer in effect?
I'm not aware of any amendments. It was put into effect prior to my employment with the town. I became employed in 2009. And since I've been here, myself, the planning board, the town council, whenever decisions have been made, I don't recall that document being considered.
Understood. No further questions.
Any redirect?
No redirect.
Anybody have a question? Any questions? I do have one.
Yes, sir.
Okay. Since 2009, has this issue ever surfaced before?
Yes, it has not gotten to this level or risen to this level of an appeal. The earliest one that I recall was from 2014. And it was a situation that I was about to explain earlier. On Ocean Boulevard, there was a piece of property. The person who was inquiring was asking if they could.
Objection.
Yeah, sustained. We don't need the detail of that individual, just the other follow-up question I have. Yeah. What happened what was the effect or what happened as a result of those discussions?
I issued a advisory interpretation, which is an interpretation that cannot be appealed to this individual. And they ultimately never pursued any form of recombination or subdivision on the property. There have been others, well, you didn't ask that, but go ahead.
Yeah. And my final question is, an approximation. I'm not going to hold you, just an approximation. How many developed lots are in Southern Shores?
I can't
Approximation.
recall that number. I apologize.
No, that's fine. Of the ones that you're aware of, has the 25-foot setback been, have they used that in the lots that you've been dealing with?
25-foot front building setback?
Yes.
For lots that were established after the adoption of the zoning ordinance, which was 1979.
Right.
The 1979 zoning ordinance established a front setback of 25 feet.
Okay, and
So lots prior to that
Yeah.
did not have
Right.
a setback requirement, at least not a town setback requirement. There might have been something from the county. I don't know.
Are you aware of any lots that does not utilize the 25-foot setback?
I recall a couple on the avenues that I've seen that were platted before the ordinance was adopted.
Okay.
I recall there's at least one where a garage encroaches that 25-foot.
But nothing, nothing recently, basically.
No, sir, we would not approve a permit application unless it meets the 25-foot building setback.
Okay. I have nothing further.
Mr. Haskett, part of the board's charge is to understand what the intent of the governing body was in adopting this language. Do you have any direct knowledge? Did you attend any meetings where this language has been discussed and interpreted or adopted by the governing board?
No, sir.
Have you had any discussions with any of the board members relative to this specific language that's at issue here?
Are elected officials?
Yes, sir.
No, sir.
Do you know of any ordinance provisions that help interpret what this language means other than its plain meaning on the face of these pages?
No, sir. Only the definitions in the subdivision and zoning ordinance.
All of which have been presented here today. Nothing else other than the materials that have been presented.
Correct. I've not used any other documents for basing my interpretation on it, if that's what you're asking.
Thank you. Based on those questions, any redirect, any recross?
Okay. Is there any aggrieved public here? Nobody's aggrieved? Okay, fine.
Everybody loves it.
Pardon me?
Everybody loves it.
Yeah, everybody loved it, yeah. Okay, at this point, Jay?
May I go to the bathroom before closing? I was talking to the clients during that break.
But real quick, let me ask you this. For the town, I have Exhibit 1, which is the entire package, including the original application dated June 22, 2022, various receipts that they paid their application fees, notices, proof of delivery, certified mail, things of that nature. Anything else documentary from the town?
That's it.
Okay? And for the appellant, we've got the appellant's package of 11 pages dated July 29, 2022, plaintiff's exhibit number 1. We have exhibit numbers 2, 3, 4, 5, and 6, 6 being the long-range planning document. Anything,
And then
you accepted the,
That would be
that's
7.
number 7. What do we call that? The model.
works for me.
Got it.
Sounds good.
Anything else?
Those are all, Mr. Wheeler.
Does anyone have any objections as to the notices that were provided to any of the parties or the adjoining property owners, anything like that? Okay. There are certain notices that have to be presented, and we just want to make sure
Yeah.
everybody thinks that everything was done by the town that should have been done. Okay, thank you. That's
Okay,
it, Mr. Chairman.
and 5 minutes? You'd be
Bathroom break.
good?
Won't even take that long.
We have a Casey break.
Yeah. Okay, we're back. The town, you're up, closing argument.
Very much. All right, ladies and gentlemen of the board, thank y'all first of all for being here today. We do appreciate the time and your service to the community. I want to start by just making clear that our position here is that this board today should affirm the decision to just deny the applicant's recombination request for lots 8 through 11 located at 55 Skyline Road, because it is our position that these lots fail to meet the town's design standards for the RS1 residential zoning district as established in the town's zoning ordinance. There was a lot of discussion earlier today, and there's a lot of moving parts. So I want to make one thing really clear, and that is that your obligation today is not to decide policy. It's not to decide spirit. Your obligation is to apply the language of the text as it's written to the facts of this case. Your decision shouldn't be based on opinions about what the code should read or the desirability of the project or the feasibility of the project. Instead, this decision should solely be based on whether an applicant has provided substantial, competent material evidence that the town has misinterpreted the zoning requirements and denied the application. In other words, it's not our obligation to show that we correctly interpreted and applied the ordinance. It's their obligation to show that we incorrectly interpreted and applied the ordinance. Now, there's really three code provisions here that are at issue. And when you look at the exact language of the code, it becomes pretty clear that Mr. Haskett has correctly applied and interpreted the language to the set of facts. Now, again, 3097 of the ordinance requires that all lots in the new subdivisions shall conform to the zoning requirements of the district in which the subdivision is located. We've established here that the subdivision would be located in the RS1 Single Family Residential District. Section 36-202 of the zoning ordinance governs the dimensional requirements for that section, as you've all heard today. And again, subsection D2 provides that the minimum lot width of 100 feet is measured at the building setback line. The language of the code doesn't read that the lot width of 100 feet has to be measured beyond the building setback line, near the building setback line, at some point past the building setback line. Provides that it has to be applied at the building setback line. Now, the definition of building setback line is also pretty straightforward. It is defined in section 3657 as a line that is parallel or concentric with the street right-of-way, establishing the minimum allowable distance between the right-of-way and the nearest portion of any building, excluding the outermost 3 feet of any uncovered porches, steps, gutters, and similar fixtures. This definition, in our view, makes it clear that the building setback line is a line. It is not an area or a permissible area. It is a line that establishes the minimum distance. In other words, as Mr. Haskett pointed out earlier, we believe that this building setback line is a unit of measurement to determine the dimensional requirements on the lots. Now, it's true that a building can be placed beyond a minimum setback line, but that's not what's at issue here. The issue here is that the building setback line, that is the place where the building setback line is located on the map, is used as a point of measurement to determine whether the lots meet the minimum width requirement of 100 feet pursuant to section 36-202 D2. Again, this requirement requires all the lots to be 100 feet measured at the building setback line. It doesn't provide anything about the measurement taking place beyond the setback line, near the setback line. But if you look at the plat, it's pretty clear that lots 9 and 10 are not 100 feet wide, measured at the building setback line, which is 25 feet. And for those reasons, these lots violate section 36-202 D2. So if the board were to approve the applicant's request here, the board would be approving an invalid recombination request under the actual language of the ordinance. Now, there's been some talk about some of the prior lots that have been approved that may have setback lines that were measured beyond 25 feet. It's also been established that most of those lots, we don't know the exact number or whether it was all of the lots, were approved before the town adopted this ordinance at issue. Now, Mr. Haskett has provided that during his tenure here at the town, he has not approved any recombination requests that did not meet the dimensional zoning requirements as he currently interprets them. He's used the same interpretation in the past to give advisory opinions. He used the same interpretation in this case to give an advisory opinion to the applicant. Along with that, the advisory opinion, Mr. Haskett also suggested to the applicant that he may have better luck looking for a variance. However, the applicant has decided not to do that, and instead he has moved forward with the appeal. It is our position that the more appropriate remedy in this case would be for the applicant to look for a variance or to possibly amend the language of the text to fit his needs, or to make a motion, or to submit an application to amend the language of the text, because as the text is written and the way it reads, it's pretty clear at this point. Now, I understand that they want this text to, they think this text may, allow them to build their lots if it's interpreted to where that medium set or the minimum setback line can be measured anywhere past 25 feet on the lots, but that's just never happened, and there's no reason to start doing that today. We've got the precedent in place on this. Even assuming that some of those lots in the past were approved, with this current ordinance in place, which we have no evidence of at this point. There are a couple of Court of Appeals decisions out there that have shown that boards are not required to follow what they have done in prior cases. Actually, in Hardin versus City of Raleigh, this is a 1926 case from the Supreme Court of North Carolina. That court recognized that the board's exercise of its quasi-judicial function does not subject the board to the objection that the board has dealt with similar cases in the past without regard to uniformity. Another case from 1999 out of our Court of Appeals, Through the Looking Glass Inc. versus Zoning Board of Adjustments for the City of Charlotte. In that case, the Court of Appeals declared that the Board of Adjustment was, quote, not required to grant a petitioner a variance merely because it granted another petitioner a variance for the same type of property in the same distance. I know we're not dealing with a variance today, but the same logic would apply because like this hearing today, a variance is a quasi-judicial hearing. So to kind of sum things up, again, your obligation today, it's not to decide policy. It's not to decide what the ordinance should read or anything like that. The obligation is to apply the language of the ordinance as it's written to the facts of this case. This decision shouldn't be made on any kind of opinions about, what this policy should be or the desirability of the project or the feasibility of moving the lots back. Instead, this decision should solely be based on whether the applicant has provided substantial, competent material evidence that the town has misinterpreted the zoning requirements and denied the application. We don't believe that they've put forth such evidence today. And again, it's not our burden to show that we interpreted this correctly. It's their burden to show that we interpreted it incorrectly. It's our view that they haven't provided substantial, competent material evidence that the staff misinterpreted this definition of building setback line and wrongfully denied the application. As mentioned earlier, the town staff appropriately used the building setback line as a unit of measurement to determine whether the applicant's lots met the width requirement of 100 feet as set forth in 36202D2. And as demonstrated, it's clear that the minimum building line or the front yard setback on the lot shown is on the map anywhere from 46.2 to 47 feet instead of 25 feet. But even if you move that line up to 25 feet, it's clear that the two lots in the middle, at no point are they going to measure 100 feet in width. So for those reasons, we would ask that this board uphold the decision to deny the application. Thank you all for your time today.
Chairman, members of the board, first off, thank you guys. It's been a long hearing. I've been through quite a few of these. This is one of the longer ones. So I appreciate you guys indulging us and listening to these obviously complex issues. I do want to note, though, that what we're talking about here is an interpretation. I think that's important. Mr. Haskins, I've dealt with Mr. Haskins. He's a fantastic planner. It has nothing to do with his ability to operate as planning director, but he has testified to the fact that he's got no direct knowledge whatsoever of what the legislators, meaning the town councils of the past, intended when these ordinances that we've been discussing were adopted. And as Mr. Wheelis put in his report, you do. Intent's absolutely critical to these particular interpretations or cases involving interpretation. You must decipher an intent in order to interpret. As far as the ordinances in play, not to be redundant, but since it's on my paper, 30-97, it's true. It states that, in subdivisions, all dimensional requirements of the particular zoning district must be met. No dispute there. 36202D2 establishes that the minimum lot width must be 100 feet measured at the building setback line. You go over to the definition of building setback line and we find that this is a line parallel or concentric to the street right-of-way, which establishes the minimum allowable distance between such right-of-way and the nearest portion of any building. Then, of course, we've got 36202D3, which states that the front yard setback is a minimum of 25 feet. Now, what I really want you guys to consider is this. I asked my witness earlier, would this be a different situation? Would you guys consider this a different code if
it read front yard setback 25 feet? Or is that the same thing as a code that reads, as this does, front yard setback minimum of 25 feet? Mr. Willis pointed out something in his report, which I liked, which is that dictionaries do come in handy in cases like this. The word minimum has a meaning. It means least. If you have least, you must have most. Well, we don't have anything in this code. We have nothing which establishes that there's a maximum setback, that this is as far as you can set yourself back. We have something that says this is the least amount of setback, that you must be set back this far. Again, without some language that requires a static 25-yard setback, which in our opinion, I mean, perhaps the only way to do that is to remove the word minimum, then we're stuck with a scenario where we've got an ambiguous code. And we've got, in our opinion, we've got an interpretation that says that any exempt subdivision lot for building purposes must be set back at least 25 feet, because that is the definition of minimum. Again, if there's a minimum, if there's a least, there must be a most. So we had an expert today testify going to substantial and competent evidence, a man who's been in business here on the Outer Banks and working with Outer Banks towns since 1984, 1985. He's never heard of a scenario where a town utilizes the word minimum, but then doesn't allow, just because of the very nature of the word, doesn't allow an owner to be more restrictive than what the least is. So quite honestly, I feel that's something that's very prevailing in this particular matter. And again, as far as all of the code requirements that we've been discussing, as has been testified to by Mr. Bissell, you take our interpretation, and there's also no dispute that our lots would meet and comply with the code if you take our interpretation. I see two very critical components that I'm asking you guys to consider when it comes to your analysis of this whole interpretation issue. One is, again, there's no explicit authority in the code for the town to require a static or a setback line of 25 feet. Our position is pretty clear, we think. I mean, at best, the code's ambiguous, as I've said. Without removal of that word minimum, you have subjected yourself to, okay, well, again, if there's a minimum, then could there be a maximum? Should there be a maximum? That's what ambiguity is. And pursuant to North Carolina law, and Mr. Wheeler said this as well, ambiguities, if you determine one to exist, then you must rule in the least restrictive manner as far as ruling, or in other words, you must rule in favor of the landowner. And we believe certainly that ambiguity exists. And I mean, obviously, if you get outside what the code gives you the authority to do, now you're committing ultra vires actions, which can be brought up on appeal, and which attorney's fees now are allowed pursuant to statute for homeowners in these particular cases who prevail. And what I'm asking you guys to realize is that there is ambiguity here because, again, our reading of this code, if you have the word minimum, and I know I keep saying that, but it's also splattered all over the code. If you have that word minimum, then you subjected yourself to interpretation, to ambiguity. And we believe, and as Mr. Bishop testified to, if a homeowner wants to be more restrictive, and all it says is that there's a minimum, as long as he's not exceeding that minimum, as long as he's not encroaching on that minimum, then the homeowner's done his job in submitting his plan. Because again, there's no language regarding a requirement of something static. And the second part that I focus on as well would be the definition of building setback line. This does apply all the way across the RS1 district. I mean, it applies across the town. So, you know, you guys can, and it's not in evidence today, but I'll make the point, and I'm sure you guys are aware of it. There are scenarios where plats and things of that nature, even in Southern Shores after 1979, where plats created more than 25-yard front setbacks. In other words, the plat set itself, there's a 100-yard front yard setback. Those lots exist. Why? Because the word minimum, you're not encroaching on that 25 feet. That's why these covenants and that's why these setbacks can exist. So again, we just plain and simple don't feel as though that to take an interpretation that use of this word minimum means a must, it just doesn't jive. It doesn't jive with the dictionary. I've searched Merriam-Webster, Oxford, Black's Law, you name it. And what you get is established means to bring about, okay, to bring about. Well, that's what my clients have done. They've brought about a lot or 4 lots that do not encroach or meet that minimum setback. Why? Because they're more than 25 feet off of the right of way. And again, there's of course been testimony as to how this better complies with the spirit and intent of the ordinance. Ms. Collins mentioned or had my witness read the synopsis within the long-range planning. No mini hotels, and I think any of us locals, we understand that more than most. Well, we've got testimony here today from my clients who state that from a financial perspective, you do what the town's asking, you can have a bigger building footprint. That's what you're going to get. The less lots, the bigger the house. That's all there is to it. So again, just from a principal perspective, but also from complying with the intent of this ordinance, you allow these 4 particular lots, which by the way are peculiar. Why? Because of this excess acreage. The only reason my clients are even able to configure their lots in such a way that we believe they comply with the ordinance is because they have all of this excess land abutting to the west or immediately adjacent to the 4 lots that were part of the original subdivision. Well, we're trying to make the best use of that land as far as we're concerned, but the best use for the town. And as we've tested, and as you've heard the testimony concerning density, you've heard the testimony concerning saving the topography. You've heard the testimony concerning keeping the orderly neighborhood in play. Well, I mean, if that's what if the big home using these 2 lots is what Southern Shores desires, and that's what they feel more complies with the intent, then okay. But 4 lots, which again, comply as we feel with the ordinance, that are going to provide a smaller building footprint, that are not going to allow for the larger homes, that we feel that's more accurate and more in line with the spirit and intent of the particular ordinance. So, I mean, I suppose what I'd leave you with is that we have provided substantial and competent testimony. We've had 2 experts, one in the field of civil engineering, who's dealt with local governments forever, one in the field of architecture, who's been able to talk about the possible uses of the land using our subdivision proposal. And whether you go or buy into the interpretation that we're making, which is that you've got an ambiguous code here, and North Carolina law says in the event of ambiguity, you must rule in favor of the landowner or the least restrictive use of the land, the least restraint, the decision that affects the least restraint on land. Or you say that it doesn't comply with the spirit and intent of Southern Shores ordinance concerning the RS1 district. Either of those arguments we're fine with if you rule in our favor, of course. And that's, again, based on the evidence we presented, exactly what we're asking you guys to do. So I'll leave you with that, and just again ask you to really consider whether you think this code is different if you take out the word minimum. Because if the code's different, if you remove the word minimum, then minimum has a meaning, and you must apply some form of interpretation and definition to that meaning. Thank you very much.
Mr. Chairman, that concludes the hearing. Board members, you are to make one of the following decisions. affirm in whole or in part the denial of the recombination, reverse in whole or part the denial of the recombination, or modify the denial of the recombination. Each decision requires a 3/5 vote, not a 4/5 like in a variance. A simple majority, again, carries the day. The chair will now guide you through your discussions and decisions.
Okay, what I would like to do is hear from each member and their thoughts and arguments, yay or nay, just what your thoughts are. We'll start down this end.
I'll keep my thoughts to a minimum. A minimum is a minimum. You couldn't exceed it.
I just think the town has made the correct move, and the applicant should have asked for clarification before going through all this process.
Linda?
I believe the town's been consistent in previous evaluations, and so I believe the town has interpreted correctly.
Jan?
I agree with that, the interpretation, and it should have been pursued before.
Okay, my opinion, or not opinion, my version is, I have a lot of trouble with this. Because you have the spirit and you have the letter. And the spirit of the town has always been how the town interpreted the law, or the ordinance, never not the law, the ordinance. The letter of it, I have to go by what is written. And to me, what is written, and I think the valid point is minimum. I had a hard time, I've researched this for a couple days. And using the word minimum really causes a problem to me because it's subject to interpretation. What is the minimum? I don't know what the minimum is. And I think a point that was a good point that was brought up is the height aspect. The minimum is 8 feet, but if somebody says 10 feet, nobody's going to say, can't go 10 feet. You know, it's actually conducive and better for the thing, the building. I also believe that this is, using this is with the interpretation of the law, it's kind of getting around things, basically, I think. Everybody knows here, I believe, that 25 feet is what has been used in this town forever, that I know of. I know, and that's why I asked Mr. Haskett, why are there any places that do not use 25 feet? And he couldn't come up with any. Everybody uses the 25 feet. However, the word minimum causes problems, and I think minimums on not only on the front setback, I think on all of the setbacks, using the word minimum is subject to interpretation. And because we have to go with, if there's ambiguity, we have to go with the landowner. I probably, even though the spirit, I think, is being twisted of the town of Southern Shores by going over 25. I've always said you have to go by what the regulation is unless there's a really strong argument that they're against it. And so anyway, that's my opinion. Now we'll have the vote. Okay. So what I need is those that wish to affirm the town, please vote and say.
Let's do this.
Go ahead.
If there is a motion presented to you to affirm
Okay,
or
deny.
deny, then that motion will be before you if it gains a second, and then you can discuss it.
Okay. Do I have a motion? I mean motion. Do I have a motion to affirm the town?
So moved.
I have a motion. Do I have a second of that emotion? Second.
Mr. Chairman, there is a main motion before you to affirm the denial of the recombination. It is open for discussion.
Yes.
Already said.
Anybody wish to discuss the motion? If there's no discussion to the motion, we'll have a vote at this time. All those in favor to affirm the town, please say yay. 1, 2, 3. We have 3, so the motion is carried and it is affirmed. Pardon me?
You might want to ask for nays, so it goes on the record.
Okay. Nays, do we have any nays?
We have
2.
2.
Okay, at this point, 3:35, we are,
Could I offer a comment?
yes, if you wish, it's already voted on now at this point. but-
Understand, I did not want to interrupt. What it actually does, and there's experts here that I would defer to. When you make it one measurement and one measurement only, I think based on the geometry of properties in lots, it constrains solutions that would meet the spirit of the town.
That's a good argument. I agree.
It is.
Mr. Chairman, each of your decisions must be supported by facts, findings of fact. I don't think that there's any better factual recitation of supporting that motion than Mr. Hallow's argument on the stand. So I know that those comments will be drafted. And does the board choose to adopt his argument as the basis upon which this decision is made?
Yes.
Thank you.
And I believe that concludes the hearing. Do I have a motion?
To close the hearing.
Yeah, do I have a motion to close the hearing? Oh, please, somebody say yes. Do I have a motion?
Yes.
Do I have a second?
Second.
All right, all in favor of returning back to the agenda, because you still have a couple of items on the agenda, say aye.
All right. Okay,
Opposed, say nay. The ayes have it. Mr. Chairman, that concludes the hearing, and you're back on the agenda.
yes. Public comments, do we have any? Planning board member, you have a comment? Become public.
I'm sorry, I missed that.
I'd just like to refer you to Exhibit E in the packet that you received before. There were several of you that asked about whether or not this 25-foot setback requiring 100 feet width was heavily enforced in the town. And anywhere that there are curved streets and there are cul-de-sacs, there is not 25 feet back. There's not a 100-foot width at 25 feet. And Exhibit E shows you how prevalent it is in the town.
Thank you. Any other public comments? Planning board member comments, we've already heard. Does, Mr. Law? Good. Linda, Jan? Okay. Any announcements? I do not have any announcements. So you, Wes? Okay.
Last night, Town Council approved PSP 2201, the subdivision request at 267 Hillcrest Drive. They also unanimously approved ZTA-2108 and ZTA-2210, all three as recommended by the board. The next meeting is, next planning board meeting will be October 17th. The agenda may contain the ZTA submitted by Mr. Varnell on behalf of Ms. Pledger. And also discussion of commercial design standards. And lastly, we are looking into scheduling a joint meeting with the town council and the planning board on November 15th at 9 a.m. I'll be in touch with you all to see if that date and time works for you all. And this would be in regards to the land use plan update. It will be a joint meeting. That's all I have, Mr. Chairman.
Okay. Anybody have any closing? Okay, at this point, can I have a second?
To your motion?
Second, motion to adjourn?
I motion to adjourn.
I'll second it. All those in favor? Thank you.
Thank you, guys. Thank you very much.